1.2 Right to be forgotten. Actually, this topic was in news because of one case. A man who carried sexually transmitted disease married a woman without informing about that disease to her. After knowing about this, that woman has filed a case against her husband, and the details of them were in a public domain. As their personal details are in public domain, she filed a petition through Right to be Forgotten and Right to Eraser. She also stated that keeping their details in public domain causes embarrassment, social stigma, and also breaks her privacy. So, the Supreme Court has finally directed to remove details of the couple from the search engines and internet. So, now we will study and know about the complete details on this right to privacy or the right to be forgotten. Okay, now look at this box here. So, under Article 21, the right to be forgotten involves removing information that was in public and also disables granting information access to the third person or the third parties. Now, here, the right to be forgotten concept was taken from the French jurisprudence of right to oblivion. Okay, here it is right to oblivion. So, this right was used by the offenders who has completed their punishment. So, they used this right to erase their personal details so that they can live peacefully in the society. However, this right was not absolute right. Some of them have restrictions. Even in European Union also, uh, this right to be forgotten was recognized as a statutory right. And Article 17 of the General Data Protection Regulation removes links. Okay, general data, it is here. So, as per General Data Protection Regulation, it grants right to erase the details. So, in Russia also, in the year 2015, they enacted a similar law like right to be forgotten. They passed a law that allows users to force a search engine to remove links to personal information if it is irrelevant, inaccurate, and if it is violation of law, then they will remove that information. Okay. Now in USA also, in USA there is a huge support for the right to be forgotten, but still it is not supported by law. Remember, in USA it is not supported, whereas we have this right in Russia, European Union. Okay, so in India at present, we do not have any law which provides right to be forgotten. Previously we would have the personal data protection bill. Okay, previously we would have this personal data protection bill, but it was withdrawn back. It was withdrawn, and we have information technology rules 2011. Okay, this one, which governs digital data, but it does not have any provision related to this right to be forgotten. Okay, so but we do not have right to be forgotten legally, but the Supreme Court strives to protect our right to be forgotten act. We have few cases. Okay, in that the first case is KS Puttaswamy versus Union of India. So this case is one of the famous case. It is in this case that the Supreme Court recognized the right to be forgotten as a part of right to life under Article 21. Okay, but it also states that it also states few restrictions towards this right. And under the right to freedom of expression and information, the right to be forgotten is not applicable. And similarly, for fulfilling legal responsibilities, for performing duty in public interest, for protection of information in public interest, for using legal claims, and for scientific and historical study purposes the right to be forgotten is not applicable. So these all are the restrictions of the right to be forgotten. Now we can observe that all these restrictions to right to be forgotten is reasonable, but still we have few issues with this act. The first issue is the data is scattered everywhere and it is almost difficult to remove all the data of a person. When it comes to deleting the pornographic material, the success rate is of the government is very low, and for this reason the right to be forgotten is not implemented efficiently in India. Even if the government or the concerned authorities remove the data from the internet, there is again a high chance that the data can be re-emerge. So there would also be a clash between this right to be forgotten and also the freedom of speech and expression. Okay, and if right to be forgotten is supported in some cases, then the freedom of speech and expression would be in risk and vice versa. And it is the same way, right to be forgotten might also clash with the public interest also. Assume if a person is effective, is like, if a person is affected with the COVID and hides his identity under this right to be forgotten, then public interest might get collapsed, right? So there are few issues with this right to be forgotten also. Now coming to the way forward, right to privacy and freedom of speech and expression should be balanced. Government should frame a strong data protection policy to prevent misuse and leakage of the data. And right to privacy also, this right to be forgotten, that means the right to privacy and the right to be forgotten must be balanced, and removing the data after specific time frame. And government should take initiatives to protect life of an individual, to protect from assaulting and infame by enforcing this right to be forgotten. And there should be a balance between this right to be forgotten and the public interest. And if both collide, public interest should be given more importance than this right to be forgotten.